First of all, welcome. I'd like to welcome you all to the AJLS panel meeting. We have already formed a quorum. I now call the meeting to order. Since the last meeting, we have issued one information paper, that's paper CB bracket 4766 bracket 01. It's a paper entitled Proposed Amendments to the Official Administrator's Accounts Interest Rules provided by the Judiciary Administration. That's an information paper that has been issued to members. Item 2 on the agenda, items for discussion at the next meeting. Basically, there are two papers, CB bracket 4794 bracket 01 and bracket 02. Members may wish to refer to paper bracket 01. Proposed items for discussion at our July meeting. There are two. Number 1, Administration of Justice Miscellaneous Provisions Bill, and the administration will be briefing us on the content of the bill. And second, Mechanism for Handling Complaints Against Judicial Conduct. If there is no objection, then that's set. Two items for discussion at our next meeting. And originally, we would very much like to discuss the issue of resources for the judiciary, because we are concerned whether or not it has sufficient resources, and as a result that might give rise to many problems. But then the judiciary said that it is not ready, and it has not prepared all the information for our discussion. And if we want to discuss that, then we may have to wait till the next session. We are very sincere, and we'd like to discuss whether or not there are enough resources for the judiciary. And the second item is a list of follow-up actions, and there are many issues that members might wish to raise. So this is for your information. After the last meeting, the Secretary has also issued a notice to members to consult you if we'd like to hold a meeting on the 11th of July. Well, 1 has no view, and 5 have not indicated their views, and others are either in favor or against it. And if you find it agreeable, then on the 11th of July, Thursday at 2:30, we can have a meeting. But then we will be discussing the two items that I just said, Administration of Justice Miscellaneous Provisions Bill, and also Mechanism for Handling Complaints Against Judicial Conduct. And I'd also like to inform members that on the 10th of July is going to be a council meeting, and then on the 11th of July is the second day of the council meeting, and we are still not sure if the President might decide to adjourn the meeting of the 10th until 2:30 of the 11th, and if that's the case, then we will have to reschedule a meeting to the 23rd of July at 4:30. So any comments on that? If that's okay, then we'll be reminding you once again if 11th of November is not available, because the council meeting on the 10th has to overrun and spill over to the 11th, and we will have to reschedule it to the 23rd. Item 3 on the agenda, implementation of the recommendations made by the Law Reform Commission, paper number CB bracket 4 794 bracket 03. Paper on implementation of the recommendations made by the LRC. We'll be inviting the LRC representatives to join us. At the same time, we'd like to welcome Mr. Rimsky-Yun, Secretary for Justice, and Mr. Stephen Wong, Secretary for the LRC. So please invite all the representatives to join us. Thank you. Members may wish to refer to the paper in paper bracket 03. It sets out the reports over the years and also some of the recommendations by the LLC. So first of all, Mr. Rimsky-Yun, can you walk us through the paper provided by the administration? All right, as for J. Thank you, Madam Chair. Thank you, members. This is the first time that we have done so in response to the recommendation by the panel and also the recommendation of the House on the implementation of the recommendations made by the LLC as the S4J, and also as the chairman of the LLC, I have the responsibility to make sure that Hong Kong's legal system will move with time, and we also work closely with all the panels, and that would also help law reforms and the implementation of all the recommendations therein, and both myself and the CJ attach a lot of importance to selecting the appropriate subjects for the consideration by the LLC. I'll be working very closely with the policy-making bureaus and departments to follow up very closely on the recommendations made by the LLC. That's very important. And also in response to the recommendations by the LLC, in October 2010, we have issued a set of guidelines requiring all bureaus and departments to provide public responses to the LLC reports under their purview within specified time limits. I'm glad to report to members here that up till now the guidelines have been complied with by all the departments and bureaus, and since last year the LLC has also introduced a new reporting mechanism, and in order to facilitate panel members and other panels and also relevant policy bureaus and departments to follow up on the recommendations made by the LLC and also the implementation of the recommendations, the guideline has been followed. I'd like to say that as a society practicing the rule of law, the LLC's reports are very important, and as society develops, we must also change our laws in order to meet the needs of our society. And for every study item by the LLC, the purpose is to improve Hong Kong's laws and is making recommendations for those purposes. And in order to ensure that there will be healthy development in our legal system, what's equally important is that the recommendations by the LLC can be fully and considered in a timely manner, and wherever practicable, they should be implemented as soon as practicable. Well, whether or not such recommendations should be implemented and how they should be recommended would have to be considered by the relevant bureaus and departments, and when necessary, they will also have to conduct further rounds of consultations before these recommendations are implemented. I'm sure members have all received an information paper for discussion today. And we have also set up a chronological list of the LLC reports published since the 1st of January 1982 with implementation status. I can also add one point why we have provided this list since 1982. That's because this is the first time that we have adopted the new mechanism in submitting a report to this panel. That's why, for the purpose of providing the full details, we have provided the list dating back to 1982. And altogether, the LLC has published 61 reports since 1982 on the substantive laws, on the criminal and civil law system. And out of the reports, one recommended that there would be no reform at all, and that is item 38, and 38 have not been accepted by the administration, and that's 7, 11, and 18. And 2, according to the response, the administration was inclined to not implementing the recommendations for the time being, and that is 34 and 35. And what's encouraging is that 33 reports have been fully implemented. That is 1 to 6, 8 to 10, 12 to 17, 19, 20, 22 to 29, 33, 37, 40, 44, 49, 54, 56, and 58. And 5 reports have also been partially implemented, including 21, 36, 43, 45, and 53. Hence, All in all, the implementation ratio of the reports is about 62%. I'm concerned that there are still some LRC reports that have yet to be implemented by legislation or administrative measures. And since assuming office as the Secretary for Justice on different occasions, I've already put it to the administration that we will have to speed up the process of implementing LRC reports. And I can also report to members here that other than the reports that have been implemented or recommendations that there should be no reforms or reports that have not been fully accepted, and also for reports that the administration has indicated that it has no intention to implement all the recommendations at this stage, all the other reports have been positively responded to by the administration.
The administration has considered the LRC's recommendations, and in fact progress has been secured in terms of long-term implementation, including legislative proposals that will be adopted in the next 2 to 3 years. And these are 17, 30 to 32, 39, 41 to 46, 50 to 52, 55, 57, 59, and also 61. Altogether 17. Together with LRC members and members of this panel and other panels, I will continue to monitor the progress of implementation, and according to this present mechanism, I will report to the panel every year, and next year I will be submitting the second report. Thank you, Chairman and members. Thank you, Mr. Yun. Mr. Wong, would you like to supplement? Now the floor is open to members for questions. Right now there are only 2 members who have raised their hands. I'd like to see how we can manage the time. There are 3 now, and I will grant 5 minutes to each. First of all, Mr. Wong Yok-man. Thank you, Chairman. In principle, we support this present arrangement that you report to us every year, the progress of implementation of LRC recommendations. The LRC is an independent body, and its membership includes, of course, counsel, but there are also non-lawyers, academics, and professionals from other trades, so that you will conduct research into possible law reforms. But then this arrangement is also problematic in that the administration's influence on the LRC is too great. It hurts the independence of the LRC. Under the basic law mechanism, the administration has almost the total power of raising bills. Strictly speaking, we cannot actually propose any private members' bills because we are subject to so many constraints. And then even if we do, we are subject to the split voting system. So the administration has interfered deeply into the law reform mechanism. My view is you should turn it into a civic and professional-led system. Under the present system, only the SJ and the CJ of the CFA can refer subjects to the LRC for research and study. I'm of the view that the legislature, being the body to make laws, should be given the same powers, that we should be able to make recommendations of possible law reform research to the LRC so that the process will not become over-politicized, and also there will be a channel for the civic community to propose such recommendations, because the legislature is a body representing public opinion, and so law reform and legislation would be closer to the public. But you have not thought about that kind of improvement. Number 3, LRC usually takes a long time to do research. From the time of referral to the publishing of a report, usually it takes years, and then if it is accepted by the administration, there will be consultation, and then you look into feasibility, etc. And then the final result will be quite outdated. I do not want to cite examples here because there are too many, including the stalking research. You remember, times have moved so much after the final report was published. Would the LRC consider expediting the process? And if there are less controversial subjects, can you do it in a more simplified way? For more controversial matters like anti-sexual orientation discrimination, you take more time, then we can understand because it's highly controversial. And I also like to advance a view. I think the administration has to give us more information. In fact, the SJ has mentioned that in his report. And that is in terms of law reform recommendations made by the LRC, how many of those have not been accepted by the administration? I need figures and the actual content. Number two, this is important. How many of the LRC recommendations have been accepted by the administration but were not supported by the legislature? In other words, the legislature threw out those recommendations when they were made available by the administration. Very often, if the recommendations of the LRC are not implemented, it would reflect that the composition of the LRC and maybe the referral system was problematic. I can give you an example. I remember the law recommendations about unsafe products and its civil liability. You said that there was not a big opportunity for a consensus to be forged, and so it was glossed over. On the face of it, it was not controversial. So why did the administration say that possibly there would not be a consensus forged? Now, we should do the easier part first, and I think that was an easier part in my view. Now, SJ, this is my view. If you disagree, do respond so that I can think further. And the last thing I like to say is that the LRC once recommended that the administrative measures should be adopted to look at the conviction record of sexual offenders. At the security panel, I said that I had reservations about this proposal. I'd like to point out that this will become an easy excuse for the administration. In other words, they can take administrative measures to circumvent the legislature. With regard to this checking of sexual offense record, it has been on trial for a year, but then there has not been any legislative effort coming up on the part of the administration. So this is an excuse for the administration to do it by an administrative means, and that can be quite protracted while the problem remains. Thank you, Chairman. There are just 3 members, so I will allow more time. Mr. Dennis Kwok. Sorry, would you like to respond? Chairman, can you not allow him to respond? Yes, I will be more lenient with the time. Chairman, if you do not mind, I would like to give a brief reply to Mr. Wong. Mr. Wong, thank you for those questions. There are a few points that I like to state. Number 1, law reform can of course be referred to the LRC, but that's just one channel. However, government departments can make such recommendations, and civic organizations and the academia can also make recommendations. Why don't you include the legislature? Well, actually, legislators are always welcome to make recommendations. Just now, Mr. Wong referred to the introduction of bills, but actually that is outside the remit of the LRC, and that has something to do with the basic law, but I don't think I should go into that today in detail. Just now, Mr. Wong asked whether we could introduce new thinking to expedite the process, because Mr. Wong said from the referral of the topic for research until the report, and then when recommendations are done and then consultation is done, and times would have moved ahead when we have the final report. I can tell Mr. Wong here that I do understand the problem, and I am conducting some informal consultation to see whether or not we can find ways and means to design a new system. And I can tell Mr. Wong that at the LRC, we have taken up such a topic at one of its meetings. But frankly speaking, this is not an easy thing to handle, because it is not that the LRC has control over the entire process, but we do understand the issue and we are doing follow-up. Mr. Wong asked whether civic bodies or that there can be other ways to tackle the work of the LRC. And in fact, I said I was aware of this, and maybe members here will remember that it was like 2 years ago. There was a law firm and Hong Kong U. They conducted a seminar to consider having a neutral LRC system, which is found in some countries. We are aware of that. Thank you, Chairman. Thank you, SJ. Mr. Dennis Kwok. SJ, with regard to the formation of the LRC, of course, the SJ would know that you rely on public figures, including law professionals who make use of their private time to work on a voluntary basis on the LRC, and that system has limitations. I don't know whether the SJ has considered making more provision for the LRC. What I mean is, on the LRC of the UK, there are 5 full-time people serving the LRC. In other words, they would think of what is to be done, and also they have a group of experienced law draftsmen helping them so they can work more efficiently and in a more professional manner. I don't know whether Hong Kong would follow in those footsteps so that the LRC can move ahead with the times, so that when the workload increases, there can be this kind of reform. SJ. Thank you, Chairman, and Mr. Kwok for your question. We are aware of that situation. Apart from what Mr. Kwok said, and he mentioned the UK model, I can also say that in other common law jurisdictions, there are different setups. For example, some would rely on university academia to be the leading parties, and in some other countries there is a hybrid model. As to which model is good, I think the model has to serve that particular place. As I said, after I assumed office, I have looked at different issues, including whether the research is done in a rather slow manner and whether there can be other reforms. And in fact, we have looked at this in our review of the system. But frankly speaking, this does not only have to do with the model or setup of the LRC, but it has an impact on resources as well. And therefore, we need more time to take care of the issue. But I can tell Chairman and members that after I have assumed office, this is one of the issues I have paid attention to, and I have talked about this with different parties. SJ, so you also agree that we should all give consideration to allowing full-timers to serve the LRC, or that the chairman at least should be a full-timer. The Civic Party is behind this. We hope that the LRC can be a more efficient and more devoted body in looking at law reform recommendations. Of course, after they have published reports, whether the administration would actually follow the recommendations, that's another issue. We understand the administration can move rather slowly. That is one problem, but if we want to reform the system, we can start with the LRC itself, and we will support it. Thank you. Yeah, it's about efficiency. Thank you, Mr. Kwok. I think I can say here that I like to have more resources so we can work more smoothly. The LRC Secretariat is served by full-time government counsel. But honestly, sometimes the research work is rather complicated because sometimes we like to do comparatively law studies so we can look at the situation in different jurisdictions. The time, therefore, needed and the resources would be quite substantial. if we can secure more resources in this regard, if we can have input from outside the legal department, whether it be council or from the universities and anybody from the community, we would welcome that.
Next, Sid Ho. Thank you, Madam Chair. Well, for resources of the LRC, indeed, they are very inadequate. For example, on the 1st of this month, at the question and answer session of this council, the administration told us that the LRC has set up 2 subgroups. One would be looking at the archive law, and the other one would be looking at the access to information. But then when I browsed the website the other day, you didn't have the resources to update them. And for the subgroup on access to information, actually it was set up in May, and yet by June it was still not updated. So what is it, because of the lack of resources or what? I don't know. But if it's because of the lack of resources, then the S4J would also have to let us know, and then we will have to fight for more resources from the FS. And if it's the problem of lack of resources, then the problems could be protracted. Other than the fact that many of these issues are very complicated, it could also have other implications. For example, on interception of ICSO, all right, well, back in 2006 it was enacted, and then there was this court case filed by Mr. Leung Kwok Hong, and then we hastily introduced this law, and it's already close to 10 years. And in 2007, we also started to study the issue on the sexual offences that was started in 2007, and still nothing has come about. So I understand that the LRC has certain no-go areas. For example, if the administration has already made it clear that there will be no policy change or there will be no legal change, then it's not likely that the LRC would be looking into those areas. If the administration has already made it clear that there are no need for further legal reforms, well, yes, the administration has finally agreed that, on the archive law, yes, that can be reformed, and also on access to information, that can also be reformed. That's why the LRC is now beginning to look into it. But then if you look at para 5 of the paper, actually the paper has already made it clear that you're going to conduct a consultation in most cases. But then when you prepare the consultation paper, would you be consulting the stakeholders and also academics with expertise in those areas? Will they be enlisted to provide input to your preparation of the consultation paper, or else we will have to wait till the LRC experts, who are just legal experts, who will be preparing the consultation paper? So that's not going to help if they are not experts in the area, because if the LRC report is used by the administration as an excuse for dragging the feet, because it can easily take 3 or 5 years for the LRC to prepare its report. For example, for archive law in 2002, we already had a guideline, and in 2009, we also responded to the community's growing importance attached to archive, and there was a further tightening up of this, and this council has been following up on that very closely. And as a result, the enforcement agency of the administration has also tightened the rules, and the Audit Commission has also looked into it, and now the Ombudsman is also looking into it. So with these pressing issues, and there is also no divergence in opinions within the community, can you expedite the whole process? And also there is already a consensus in the community. Actually, we have even got a private member's bill on archive law. So would you be soliciting the views of the stakeholders instead of starting from scratch? And finally, I'd like to put this to you. All right, for the consultation on archive law, many groups have already made it clear that for the access to information and also the archive law, the two should be working in tandem, because without archive law, however hard you try to provide access to information, if there are no records, then there is simply no information that can be made available. But then if you have the archive, and if you do not provide access to that, then all those archive will just remain archive, and they will not be open to the public. That's why when you conduct the research, why are you not asking the LRC to look into the details and also the history, the historical background, and also the long-standing policy? And also you should be working, or you should be discussing with the stakeholders who have been following up on this. At least you'll be able to see the way forward. As for Jay, Yes, thank you, Chairperson and Ms. Ho. I fully understand what you meant. Well, let me briefly explain the situation. Well, for the consultation referred to in the paper, well, before we prepare the first consultation document, actually, we would be broadly consulting the different stakeholders. For example, taking the archive law and also access to information as the examples. Well, what I can tell Ms. Ho and other members is that I'm sure you are all aware of the fact that under the archive law, we do have a rather active group. I don't know what's the name in Chinese. It's called an action group on archive law. Yes, I'm also a member of that action group. All right, that's the action group on archive law. We've actually invited one of the members of the action group, who is from the University of Hong Kong. He's an expert, and he's Ms. Stacy Gu. He's one of the members of the LRC subgroup on archive law. And also we have barristers and solicitors and other community representatives sitting on the subgroup. And also in response to the point made by Ms. Ho and also Mr. Wong also referred to that point earlier, that is how do we expedite the legislative work? Well, under the two subgroups, what we are trying to do is that at a very early stage, we would invite the relevant bureaus and departments representatives to join the subcommittee in order to ensure that at the very initial stage of the subcommittee's work, relevant government departments and bureaus can give their input to the subcommittee as to the implications of any possible legislation, so that they can raise that with the subcommittee in the first instance, and there can be early discussion of these issues. I hope that when we conduct research on these subjects, that's also one of the things that we can do. So we have already got two government representatives sitting on the two subcommittees. And also another point raised by Ms. Ho is about the archive law and also Access to Information Act. Well, the two are actually closely linked. Why do we have to separate them into two subcommittees? We fully understand the views of Ms. Ho. In fact, what I can say to Ms. Ho is that, well, in deciding on conducting research into the two subjects, the LRC has actually spent some time on overseas legal framework on these two areas. We have also spent some time to specifically look at whether or not we should have one or two subcommittees look into these areas. And in the end, colleagues of the LRC are of the view that in view of the fact that in some common law jurisdictions, they also separate the two and there would be different sets of legislation regulating the two areas. That's why after detailed deliberation by the LRC, is of the view that a more appropriate approach is to set up two subcommittees to look into these two subjects. But then we also emphasize that we hope that the two subcommittees and the chairman of the two subcommittees will have a very good communication, so that in the future, by the time when the two subcommittees have come to a certain stage whereby the chairman of the two subcommittees might think that there should be stepped up communication, and if they think there is a need for them to merge, then that can be done. Indeed, before the two subcommittees started their work, I've also personally met with the chairman of the two subcommittees to make it clear to them. I explained to them in person that initially the LRC did have this discussion. Why did we have to set up two subcommittees instead of one? That's why I fully appreciate Ms. Ho's concerns. I also understand that different people might have different views, but then I have to explain to you here that we have already gone through a very detailed consideration before we decided that two subcommittees will have to be set, and we understand that there is a certain connection between the work of the two subcommittees. But when will the report be available, and how are you going to go about the consultation? What's the timetable? All right, there are two issues. Well, for the target timetable, I've also talked to the chairman of the two subcommittees, and they told me that they would have to take it up with their members before they would get back to me. And also, at the LRC plenary session, we will also be monitoring the progress. As to how the consultation would be conducted, well, we haven't got any concrete plan, but then for the time being, we plan to adopt the traditional approach. That is, we will have a consultation report, and there will be hard copies, and that would also be uploaded onto the website. And given the substantive subject involved, well, the LRC's traditional approach will be for a press conference to be held in order to brief members on the details of the report. All right, next. Mr. Lang Kwok Hong. Madam Chair, Mr. Yuen, you have not answered the question raised by Mr. Raymond Wong. That is, how many of the LRC's reports have not yielded any results? In other words, well, nothing has come about from the reports, but then if they managed to get through, but then nothing came about in the end, how many of them are like that? Well, after all, the LRC has been appointed by you to reform our legal system, but then if the recommendations by the LRC have not been taken on board, then there must be a reason. Or you have listened to their recommendations, but then there might be reasons that you're not able to implement the recommendations. So you will have to give us the figures, and you will have to let us know why that has been the case. And second, about access to information and also the archive law, well, I don't mind how you're going to delineate the responsibilities and so on. All right, you said that there are different systems in place and so on. All right, I'm not interested in that at all. The thing is, when are you able to come up with something concrete? Well, I do not quite subscribe to the view that the S4J just said. All right, as an administration, if you want to be open and transparent and be accountable, then how you deal with your records and archive is the basis for accountability. I can cite a very simple example. C.Y. Leung might have submitted certain information to you. For example, he might have owned a company of the BVI, and what are the details? I've asked many times, and he refused to answer. If this law is in place, then he will have to keep a record, and then I'll be able to invoke the access to information or archive law provisions to see if he has filed a record with a certain jurisdiction and which party has held the information. And also, under the principles of access to information, I'll be able to get the answer instead of just instead of keeping to ask him questions and he refuses to answer the questions. All right, in March, I asked him 3 times, well, for the BVI company that you own, what's the business nature of that company? Can you tell Hong Kong people what it is all about? I only got a one-line answer. All right, he invented this, and he said that you can rest assured, well, the business that I'm engaged in will have nothing to do with Hong Kong people. What kind of attitude is that? All right, if that information is available to me, then I do not have to beg him for an answer. And even now, up till now, it's almost close to the 1st of July. It's almost a year since he assumed office. It's not a year since he was elected. Still, we are getting nowhere. So, Secretary for Justice, I do not agree. This is not the problem of the LRC. It's an issue of you discharging your constitutional duty. And as the Secretary for Justice, do you have plans to just set aside the LRC so that you'll be able to work on your own? In fact, we don't need the LRC to tell you that it's problematic, it's not working well. Well, honestly, I've already prepared this private members bill, and after the summer break, we'll be looking into it. All we need to do is to copy it from the web. We can even copy it from some of the textbooks on the mainland. In fact, well, the mainland has very comprehensive legislation in place because all they need to do is to copy from elsewhere. I think it's really bothering me because you've accepted the responsibility and you're actually able to do it by way of implementing it, and yet you're passing the buck on to the LRC. SJ? Thank you, Mr. Leung, for your question. In terms of the figures, actually, we can also provide answers to the question raised by Mr. Leung and even Mr. Wong just now. In fact, in the table that we set out to the paper, in the table that is attached to the paper, we have already set out the details. For example, which paper has been implemented and which report has not been implemented and why.
I can give you an example. We tabled something to LegCo, but the Bills Committee and the Bar Association objected, and so it was not carried out and it lapsed. And that is how material could be used for legal explanation or interpretation. We said in the paper that at that time the Bar Association was of the view that we should consider the different constitutional setup in the UK and Hong Kong, and so it was hoped that we should wait for some time after 1997. And as to which had not been accepted by the administration, this is in the table. Secondly, Mr. Leung said something about CY Leung, the CE. Actually, that is not a law reform issue. It is an other issue, so I will not comment on that in detail. And also to follow up on Mr. Leung's point that actually we do not need to refer those issues to the LRC, I beg to differ. If we look at other common law jurisdictions, nearly everyone has such a setup. It is just that the model and the framework would be different. And as to whether you can copy from other laws in order to produce a private member's bill. Well, actually, this is exactly why we need different professionals and other people from the community to help us with our research, because it is not possible for us to just copy the legislation of any other place. That would not fit into Hong Kong squarely. We used to use British laws as a basis, but then we still had to give consideration to the differences between the UK and Hong Kong. On the archives law and access to information law, different places do approach the subject differently. So it is absolutely not possible to ask the LLC or the government to copy the laws from any other place. In the second round, we have Mr. Wang Yokman. Any other members from the first round? If not, in fact, I myself would like to ask a question, and then we'll go into the second round. I have this question for the SJ. There are 61 pieces in the table, and at 61 you have class actions. You said that the DJ has already set up different working groups, and you have got people consulted, including legal professional bodies and the Consumer Council. And could I ask you to report on the progress of work? Thank you, Chairman. On class action, from the time I assumed office until now, different organizations and people have given me the message that they are hugely concerned about this issue. But in fact, this is also quite a controversial subject. Different sectors have different views about having class action and whether class action will lead to any abuse, and how class action can affect the different sectors. And the views are hugely diversified. And in fact, there is this very strong view that whether we should fully allow class action to take place, or should we allow class action to tackle consumer disputes so that we can accumulate the experience before we extend class action to other aspects. And there are very different views on this as well. So we understand society is quite divided, and that is why we have got this cross-sectoral working group. It includes the business community, the legal community, the Consumer Council, as well as other sectors. And also, because it can have something to do with the judicial process, the Judiciary is represented. Of course, the judiciary would not be commenting on the policy. It would only provide views on the judicial process. Counsel from the DOJ has drafted papers for discussion by the working group. And I can also mention that since we are also very concerned about this issue and we understand that the workload is heavy, that's why we have sent a lawyer from the LRC Secretariat to assist this working group on a full-time basis. So there will be support in terms of legal research. So the first point is that we fully understand the concern of the community on class action, but secondly, we are also fully aware that very different views have emerged from the different sectors. Now, point 3, we are aware that in other countries, there have been different developments vis-a-vis class action. For example, in the US, there has been a lot of class action, and it is quite popular. However, lately, the US seems to be moving in a different direction. And then Singapore, earlier on, it researched into class action, and in the end, it decided against it. And then within Southeast Asia, the most successful example is Australia. So what should Hong Kong do? We really have to listen to different parties. Thank you, Chairman. SJ, I'd like you to say something about the US. You said they have gone in a different direction. Can you give us more details? Well, from my understanding, some judges in the US are of the view that there has been abuse, and it has aroused the concern of the US judiciary. So they are looking into the prevention of abuse. You mean there has been a lot of action brought about by class action? Well, I must emphasize that the situation is very different between the US and Hong Kong. The abuses that can appear in the US cannot or may not necessarily appear in Hong Kong. And one of our differences is the legal cost. In Hong Kong, you have to pay the full legal cost if you lose the case, but that doesn't apply in the US. So how can we prevent abuse of the system if class action is adopted in Hong Kong? That is a relevant factor. That is why I said just now that we could not just copy the system from another place. Okay, now second round. Would any other member like to speak in the first round? If not, Mr. Wong Yok Man and Mr. Leung Kwok Hong will have a second round, 3 minutes each. I'd like to respond to what the SJ said. My question was that, well, I understand you now let us know that there are 61 reports since 1982, but since 1997 there have been 27 reports. My question is, of course I understand that you have told us in this table how many recommendations have been rejected by the administration. Now, when you supply these papers in the future, please categorize these reports. Now, you are just including them as a remark. We are talking about a period of 16 years, and there have just been 27 reports, so it shouldn't be difficult for you. Now, I'd like to follow up on my question. What are the reasons for rejection? I hope you can submit another paper to let us know the reasons so it facilitates our follow-up. There must have been a reason for rejection by the administration. And then another question was, I was talking about the functions of the legislature. In other words, we cannot refer anything to the LRC. And also, we have no basis to introduce any bills. We are just like rubber stamps. We can vote yes, no, or abstain from voting on bills. And then, of course, we can be a talk shop all the time. Now, my concern is, how many of the recommendations have been accepted by the administration but were not supported by the legislature? Sometimes it was not passed as a bill, but then it would be a slim possibility. However, has the legislature rejected even a discussion on the recommendations? I'd like to know the facts, and I need figures. Just now I stated quite clearly that I can accept the present arrangement, but I think there can be improvements. I also agree with the SJ that on certain issues we have done your research, including the representatives of the LRC, and also some issues have been dragging on for so long, and in the end they just tapered off. But I need information because now you're going to report to us every year, and I hope that report would be more detailed so we can have more quality discussions here. SJ? Thank you, Chairman, and Mr. Wong, for your questions. Mr. Wong was very modest. Actually, we are not here to enhance the quality of LegCo discussions. And in fact, LegCo members are not rubber stamps at all. In terms of law reform work, we do need the support of each and every legislator. Mr. Wong made two proposals. One, that we categorize such reports. Secondly, the reasons for rejection. Yes, that can be done, starting from the second report next year. I'd like to thank Mr. Wong for this proposal. Secondly, how many LRC recommendations have been accepted by the administration but have been thrown out by LegCo? If I understand Mr. Wong's question correctly, my understanding is that we can look at point 32 in the table, and that is extrinsic materials as an aid to statutory interpretation. As I said just now, at that time the administration actually hoped to start work on this, but the Bar Association was of the view that the LRC gave consideration to a UK piece of legislation, but the constitutional setup was different, and at that time the Bar Association said that there was no rush, and they said that hopefully we could wait for some time after 1997 to take hold of the situation in Hong Kong. Now, I was aware of that after I assumed office, and we have written to the Bar Association hoping that they could comment on the issue again to see what their latest view is. We are now awaiting the reply of the Bar Association. We'll be following it up. Thank you, Chairman. Good. Mr. Leung Kwok Hong? Chairman, of course I understand what the SJ said on the archives law and the related access to information law, that he would like to consult the people. However, the question is, how long do we have to wait? I think it's laughable that you have separated the two matters into two working groups. SJ. I think if the LegCo members would like to propose private members' bills, we would have to seek the CE's discretion, especially if it has something to do with the finances and policy and governance of Hong Kong. So, I mean, every bill must have something to do with either or all of these three. I took you to court on that one, but I lost. So we could not have a proposal of bills, and also we could not do anything to the bills you propose because we cannot even work outside the remit of the long title of bills. So I'm telling you, if you don't do anything on the archives law, there is nothing we can do. And But then secondly, you move rather fast on certain things without the prompting of LRC or ourselves. The 2-tin rule about baby formula. Did the LRC say anything about the baby formula issue? If you wanted to do something, you would do it. And also the ICSO, the court said that your views would not be upheld, so you had to do something. So you really had to be ruled out of order or unconstitutional before you would act. And I'm talking about the interception of communications and surveillance ordinance. So I'm telling you that you should state your attitude clearly on the archives law so that we can move ahead. I can give you an example, Mr. SJ. If now you want to embark on an archives law and you submit a consultation paper to the LegCo, can you do that? Of course you can do that.
It's just that you're not going to do it. It's like Article 23 legislation. So I do not quite agree with what you said, that the LRC does not agree, or if there is anything controversial, then that cannot be done, because the LRC has been appointed by you. How come the appointed body would be standing in your way, or that it would not be taking your advice? That's not possible. So there are two issues. I'll simplify them. So for the on the archive law, when are you going to do it? All right, I'll be here until 2016. So before the end of my term, can you do it? All right, it's about the timetable. SJ. All right, thank you, Mr. Leung, for your observation and question. Well, Mr. Leung's observation covers several aspects. Number one, Mr. Leung said that it's an attitude problem. How come the SJ or the DFJ cannot come up with a paper on access to information and also the archive law? Why can't we start the consultation? In fact, it depends on which unit or which department would be best placed to propose the law reform. And precisely for this reason, initially when the EXCO decided to set up this independent law reform commission, that's because we would like to have a neutral and independent body outside of the government so that it can take on board views from different quarters of a community, including those from professional bodies, before proposing any legal reforms. And we also hope that in doing so, the LRC would be able to act independently without any political interference. And Mr. Leung repeatedly said that all LRC members are appointed by the administration, and there is no reason why we would disagree with the appointees' recommendations. Well, even though the members of the LRC have been appointed by the administration through the established mechanism, but then we have been emphasizing their neutrality, in particular their political neutrality and professionalism. That's why it doesn't mean that after an institution has been appointed by the administration, it will definitely take the instructions from the administration. We must not confuse this concept, because all along we have emphasized a lot that the LRC is an independent and neutral body. And also to respond to the remarks made by Mr. Leung, that is very often our legislative work, when it comes to private members' bill, we will have to have the consent from the chief executive. In fact, this is a constitutional design under the basic law. It's not something that the LRC can do about. And because of the design of the basic law, it's executive-led. Therefore, we do have this constitutional setup. Thank you, Madam Chair. All right. Does any other member wish to speak on this subject? If not, then in fact I'd like to announce that there will be a break of 5 minutes, because for the deputations that will be attending for the next item, half of them are still on their way, because we have started a little early this afternoon. All right, let's take a break of 5 minutes. And once again, we'd like to thank the SJ for coming to our meeting on this item, and we hope that for the future work of the LRC, we hope that in terms of its efficiency, And also, if there is any policy that can help the LLC to go about its work, then we've already made our views very clear today. And I hope that next time you will come back to report to us the progress. We hope that more progress can be made. Alright, thank you once again, SJ and Mr. Stephen Wong. Alright, let's take a break of 5 minutes and we'll arrange for the deputations for the next item to join us. Alright, some members have already raised their hands and they like to line up for questions